Okay, we're going to go ahead and start. The other people can catch up. And remember, these are being videoed, so you can always go to the YouTube channel and watch any session you want again, or watch them all again. My son actually Googled and found me online and was watching it. So, okay. Okay, so we're going to go to the sales contract, paragraph 8. I want to take a look at paragraph 8 and 9 and some of the statute today. One thing that you will notice about paragraph 8 and 9 in this new contract is it's about 1/3 the amount of space taken up in a contract that used to be there. They moved all of it into a separate addendum. Not a separate addendum, into a separate form for you to share with your buyer so they know the rules and regulations. We'll take a look at that after we go through the paragraphs. Also, paragraph 8 and 9, they say the same thing because last year they passed a law in the state of Virginia to basically make POA and Condo Act the same. One thing that is different is in the POA Act, you will be getting a package, and that's called something different than in the Condo Act. You get a resale certificate and a condo, and you get the package in the POA. But other than that, they mirror each other. So let's just go through paragraph 8. Now we're going to do this like we've done in the past on Wednesdays. This is line by line. Make sure that we understand what it says and my interpretation. So, seller represents the property is or is not located in a development that is subject to the Virginia POA Act. And I think you pretty much know how to find that out, but the owner should know if they are in a POA. But you can also go to the CIC, Common Interest Community Board, to see if it's registered there, or the SCC. They have to be registered and reports filed with those organizations. So section 55.1 1808 of the Act requires the following language. So next week on Monday, we are actually going to visit 55.1 1800 through 1836. That is the actual POA statute in the state of Virginia that this language is taken from. I'm going to refer to that some today, plus the additional forms. So subject to the provisions of the subsection 55.1 1814, an owner selling a lot shall disclose in the contract that 1, the lot is located within a development that is subject to the Virginia POA. 2, the Property Owners Association Act. So those two things are covering it. So the Association Act requires the seller to obtain from the Property Owners Association an association disclosure packet and provide it to the purchaser. If you were dealing with a condo, it's called a resale certificate, but it's the same thing, requires the same 19 pieces of information, etc. Okay. 3, the purchaser may cancel the contract within 3 days or up to 7 days if extended by the ratified real estate contract after receiving the association disclosure packet or being notified that the association disclosure packet will not be available. They removed the language from our statute that requires that the purchaser acknowledge receipt of the condo and POA docs. That is no longer necessary. Therefore, that form has actually been removed from NVAR's forms library. The law simply says that it begins upon delivery of the disclosure. The You have to be able to prove it was delivered, and the statute says how you do that, okay? The purchaser has received the association disclosure packet. If they have received it, the purchaser has a right to request an update of such disclosure packet in accordance with subsection 8 or subsection D as appropriate. The right to receive the association disclosure packet and the right to cancel the contract are waived conclusively if not exercised before settlement. So let's review some of this. It says 3 days or up to 7 days. These days are strict in the act, okay? The purchaser had the right to void within 3 days of receipt. In other parts of our contract, it says that documents start the day after delivered, but that does not come into play with POA and condo. The day they are delivered, the clock starts ticking, and there are 3 days, okay? 3 days from the time they receive it. It's not 72 hours. The law doesn't say 72 hours, and they do not define a day. So my opinion would be if it's received today, anytime today, the first day ends at midnight tomorrow. So that would be Thursday, Friday, midnight, Saturday, it's over. I think you're better off practicing 72 hours. It's not 9 p.m. That's an agreement between buyer and seller in a contract. You can't override statute. But since they did not define a day, actually did not define a day in the statute. To me, a day ends at midnight, so it's not 72 hours. But safest avenue, pretend it's 72 hours. Don't push the issue. Okay. Now it says within 3 days, up to 7 days of extended by ratified real estate contract. If you go to Form K-1389, extension of review period for the condominium resale certificate. This was passed into law this year that if everybody agrees, you can have an additional 4 days if these things are hand delivered or electronically delivered. But everybody has to agree. You can't limit the number of days to less than 3. That is not negotiable. What is negotiable is up to 4 additional days. This can be done prior to contract, with the contract, but you would still need this addendum, or it can be done after contract ratification if all parties agree. So let's take a look at K-1389. This form became effective July 1st when the law did. You'll notice up in the right-hand corner, it says number. So you could have a number 1. If you extended everything for 1 day and you needed another day, then you would use it again. It'd be number 2, number 3, number 4. If you were doing this 1 day at a time, if you're going for 4 days right up front, so there's a total of 7, then there would only be 1 extension. So the addendum is made on whatever the day is you're doing it to a sales contract offered on. That means the date date of offer on the first page of your contract between buyer and seller for the purchase and sale of the property. Check all that apply. You'll notice there's an extension option for POA and condo. It might be one or the other. However, it could also be both. So you might have a 4-day extension for POA because you got that document first, and then you might be looking for an addendum 2 where you're asking for an additional 4 days because you got the condo the condo package after you receive the POA. What the interesting part of our statute says that if there is 2, okay, if there are 2, the right of cancellation actually begins after the receipt of the second package. You probably wouldn't have to do it the other way, but if you wanted to, you could. So If you receive POA and 3 days later you get condo, you still have the right to void the contract for the 3 days after the receipt of the last package. Okay, which would make sense because you could do it on either package. The extension, the parties agree that the buyer's right of cancellation provided by the law, basically in this contract, shall be extended X number of days, not to exceed 4. So our statute is very, very strict. It says 3 days after receipt of any part of the documents, cannot be waived or varied even by agreement other than these 4 additional days. Okay. You also notice it says on this form under extension of condo, the paragraph under it, this addendum shall not alter, modify, or change this contract, and except as modified herein, all the terms and provisions of this contract are expressly ratified and shall remain in full force and effect. That's required basically by law, because technically, anytime you send an addendum over that parties have not agreed would be part of the contract, that might open up all the contract for renegotiation. So that's why in our home inspection addendum that we'll look at next week, it requires an addendum, which would not open up all the other terms for negotiation. Any questions about this form? We did go over it once before, but I'm trying to tie. Yeah.
Does it say anywhere that, once you receive first package, second package, 3 days from that it starts?
No, it's in the statute, and they expect you to understand what the statute says.
Okay.
And that's why we're going to take a look at it next week.
Okay.
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 Now, let's go back to paragraph 8. Pursuant to the law and purpose of this paragraph, ratified real estate contract includes any addendum to this contract. They had to add that language to our statute. And it's in the definitions that you will see if you look at the actual statute. For delivery of the packet or notice of non-availability of the packet, buyer prefers delivery at if electronic or if hard copy. Both of those blanks need to be filled out by the buyer. It's not their choice. Actually, what our statute says, if the seller delivers the document in one of the following manners, electronic or hard copy, they have met the statute. So, and I know most associations say they only have them electronic, but that's a direct violation of our statute. Our statute says that if you go to the office of the management company and ask for hard copies, they must supply them to you. Okay, so they are still available hard copy by law if you request them. Now, one of the questions I get quite often, they charge way too much for the package. So I just want to share with you from our statute, 55.1.1810, okay? It talks about the seller or the seller's authorized agent shall specify in writing whether the disclosure packet shall be delivered electronically or in hard copy at the option of the seller or seller's authorized agent. So in our statute, okay, it allows the documents to be ordered by the agent if the seller authorized you to represent them. Also, it talks about authorized agent for the buyer. Now, the package has to be delivered, okay, to the buyer as requested in paragraph 8B of the sales contract. However, the caveat of all this was if you delivered it to the agent, the time started ticking. Well, 3 years ago, the law changed in Virginia to say that, if the package was not delivered to the agent, delivered to the buyer, but delivered to their agent, then the clock started ticking. Well, that meant that if on a Friday night I dropped it off at the broker's office and somebody acknowledged receipt and the broker was the agent for the buyer, then their time started ticking. So our statute actually says now, unless the buyer has designated the agent to receive the items on their behalf, the clock doesn't start ticking until they receive it. Do you understand what I'm saying? If the documents were sent to the agent, but they weren't authorized to receive them, then the clock didn't start ticking until they were sent on to the buyer. Therefore, should your name ever be in the pack in paragraph 8B for the delivery of the documents? Probably not, because if they put your name in there and they sign this contract, then in my opinion, they have authorized you to receive the items on their behalf. And as soon as it hits your email, they're delivered. So once again, I keep myself out of the contract and make sure that it has to be delivered directly to these parties. And the statute actually requires the management company of the POA or condo to send them directly to them per the instructions they receive in the act. Okay. Now, another thing that I get a question about these fees. So here, listen to the fees. Okay. And this is in our statute. They can do an inspection of the exterior of the dwelling unit and the lot. Okay. A fee not to exceed $100. So they can charge $100 for that architectural inspection. For the preparation and delivery of the packet itself, if it's paper format, printed, the fee cannot exceed $150 for no more than 2 hard copies. 2 hard copies, $150. If electronic, the fee cannot exceed a total of $125. So far, if there was an architectural review committee, 100. If it's electronic, 125. We're at 225 for the packet, right? Now, here's the really cool thing about electronic, okay? For that $125, you can name these people to receive a copy. The seller, seller's authorized agent, the purchaser's authorized agent, and not more than one other person designated by the requester. So they have to send out 5 copies for $125 total if, when the documents are ordered, it's requested. Okay. Also, at the option of the seller or their authorized agent, you can ask for expediting of these documents, and if the association agrees, they can charge $50 for expediting, okay? Which means they have to deliver it within 5 days instead of the 14, but they don't have to agree to expedite. If they do, they can charge $50, all right? And those are the fees, okay? Those are the fees. They can't charge a fee for accessing their website or any of that. We will take a look at that on Monday when the fees are due, that type of stuff. But I'm often asked, how much can they charge? So it can be $225 plus $50, $275. There are some other fees in the law that allows them to charge things for certain paperwork not covered. But if you think you're being overcharged, just tell them. You'll be contacting the CIC to verify whether or not these charges are legal. They'll back off. So they don't want you contacting Common Interest Community Board at DPOR, okay? Now, we have that other form, K1390. I highly recommend this form, okay? Just like the form we talked about last week with useful information about real estate transaction we talked about on Monday. So if you don't have it, you can download this from NVAR's form site, or you can go back into the documents that we used before. It's called Understanding Your Rights under the Virginia Condominium POA Act, okay? Now, this is something that you give to the buyer. One is for condo and POA because they're basically the same, but they have, let's just take a look at the condo resale certificate. There are 19 items that are required for a complete package, okay? 19 under condo, 19 under POA. So just a few of these. A statement of any expenditure of funds approved by the Unit Owners Association requires an assessment, so they need to know that. And you can read through each one of these, but I'm just going to paraphrase a few of them. A statement including the amount of all assessments and other fees charged currently. A statement of whether there's any other entity or facility of which the owner may be liable for fees. So they might have a separate fee for the pools or whatever. They need to be, that should be in there. A current reserve study. I think that's one of the most important ones in there, and they have to be updated once every 5 years, but the reserves is what they use to make repairs to the units. A copy of the Unit Owners Association current budget. 7, a statement in nature of any pending actions or unpaid judgments. 8 deals with the insurance. 9, a statement of any improvements. 10, the bylaws. You can read through those. I'm not going to sit there and read them all to you, but I want you to pay attention to number 19, a copy of the fully completed form developed by the CICB, Common Interest Community Board, pursuant to the statute. So there is in section 54.12350 a form that DPOR developed that has to be attached to every package, the front sheet, and it summarizes these type of things. 1, the obligation on part of an owner to pay regular or annual special assessments. I am dumbfounded that I have actually had calls where they said, well, they didn't know they had to pay a fee. Well, it's a POA and a condo. Why would they think there was no fee? Okay. Or 2, the penalty for failure to pay the assessments. So all those are covered in the annual report. We'll look at that in a Ask Larry session on Monday. Okay.
Larry,
Now,
could you
yes.
explain the 19, a copy of the fully completed? What does that mean?
A copy of what?
What, number 19? And you said
19 is required by our statute that there be a summary sheet of the important points in the package. It's a separate form developed by DPOR that all condo and POA associations have to attach to the front of the package. Okay, and it covers things like you do know you have to pay dues. It will cover whether or not you can have pets, whether you can have trucks, motor vehicles, boats, architectural guidelines. All those types of things are summarized on the first page so that you can go in through the documents and find the things that might be of interest to you. Have you ever had anybody buy a property and find out they could not have their pet and they didn't read the documents closely enough to see that? Or they have a truck and they can't bring the truck home, a pickup truck. Here in my condos in Florida, there's no pickup trucks or motorcycles allowed. That pretty much kills 4 weeks a year when they have the trucks and the motorcycles. So we can't rent this out to anybody that has a motorcycle or a truck. So those things would be reviewed in that one-page disclosure form. Okay. Now, if you look at paragraph 3, buyer's right of cancellation. If you have K1390, it's not really covered anymore in paragraph 8 and 9. It used to be really spelled out in detail. And that's why I like this form. It's not an addendum to the contract. It's just a form that you give them so that they acknowledge that, hey, you've discussed this stuff with them and they're not going to be blindsided or come back and say, you never told me. So the information contained in a resale disclosure packet shall be current as of the date specified therein. What does that mean? Well, whatever date's on the top of that form, that's that's the most current one, then that's it. So what if I belong to an association that meets twice a year or once a year? Okay, and they already met. That I received the documents, and they're not going to meet again for another year or whatever. Well, then that's the most current documents. Okay, and if I already have that package, I could probably reuse them again. Okay, you'll see in our statute that if the documents are less than 12 months old, okay, less than 12 months old, then the seller can just order an update. They don't have to order a complete package. So if I moved in July and I got transferred out back out of town in January, I don't have to order a new packet. I can use my old packet and we can order an update, okay, which is much cheaper, right? Buyer may request an update of such resale certificate disclosure packet or financial update. However, and the however is very important, the request or receipt of an updated resale certificate disclosure packet will not extend the buyer's right of cancellation provided under the Act. It's informational purposes only. The law is very strict. 3 days from the date of receipt or 7 days of extended. If it's mailed, it goes from 6 days to 10 days, but you cannot have an agreement. Well, we got this package, it wasn't complete, so everybody agrees in writing to extend this for another 30 days till we get the documents. That's not enforceable. The law is very specific. Whatever you get, you make your decision. There is no variance or waiving any of these regulations, okay? So you have the right to the update. If you don't like what's in it, it's too late to cancel your contract, right? The buyer's right of cancellation begins upon seller delivery to buyer of resale certificate, okay? Including a resale certificate that is not in conformity with the provisions of the Condo POA Act, or seller delivery of buyer of notice of resale certificate will not be available. So there's 19 items that have to be in a complete package. If your buyer receives 8 of the 19, their time has started, okay? Their time has started. They have 3 days to make the decision without the other 11 pieces of information. Do I want to go forward, or am I going to void my contract? Okay? There is no other alternative. Now, you could ask for an additional 4 days to review, but that's, that doesn't mean that you're going to get the other 11 pieces of information in that time frame. Okay? The parties may extend buyer's right of cancellation to the extent permitted by the Act, which is, how many days? Up to 4 days, right? Any rights of the buyer to cancel the contract, listen to this, are waived conclusively if not exercised within the right of cancellation period or prior to settlement. No matter what you get, you have 3 days, maximum 7, to void or prior to settlement. If you have not received the documents, all the way up until the time you receive the documents, buyer, you have the right to void your contract unless you have received a notice of non-availability of the documents, okay? So up until you receive the documents or a notice that it's not available, you have 3 days. You can cancel at any time. You have 3 days after one of those two actions take place. The failure to receive the disclosure package shall not excuse any failure to comply with the provisions of the declaration. The law says if you settle without receiving the documents, you have waived the receipt of the documents. You are bound by all the provisions, whether you saw them or not. And I know of instances where agents said, well, I've got these documents. We've already settled. What do I do with them? it's too late, it's over, right? Paragraph B, the resale certificate disclosure package shall be deemed not to be available, okay? Deemed not to be available, okay? If a current annual report has not been filed by the unit POA with either the State Corporation Commission or the CIB, seller has made written request to the POA and the resale certificate or disclosure packet to be provided has not been provided within 14 days, or a written notice the package is not available. So technically, if you order the documents as the listing agent and you are a designated agent, on the 15th day, those documents are deemed not available. A notice of non-availability should be delivered to the buyer, and they have 3 days to what? To void the contract. They're deemed not available. Or if a current annual report hasn't been filed. So you can always go to CIC or as an agent and check and see if the report has been filed. Okay. Any questions of any of that?
Yes, Larry.
Yes.
If there's no POA or condominium association, we can leave it blank, this one or no?
Yes. We'll put NA, not applicable.
Okay, not applicable. Okay.
Yeah. Because I don't leave any blanks in any contract.
Thank you. Yeah, you told me.
Hey, Larry, quick question.
Okay.
You basically said that if we receive a incomplete POA docs and the time was, even though it's incomplete and we only received 5-6 pages, the clock will start even though we received the incomplete package?
Absolutely.
Okay.
And here's the reason. A seller can only deliver what they receive. So to hold a seller's property up, waiting for additional documents might go all the way to the end of the period trying to get the additional documents, and they've ruled that that's not fair to the seller. The buyer, you have the right to either gamble or void your contract.
Awesome. Thanks.
Okay. Now, paragraph C of this form, if you have it, it talks about canceling the contract without penalty. So number C1 deals with if you receive the documents prior. So if you have somebody that's really in a hurry to sell their house, okay, and it's in a POA or condo, okay, then have them go ahead and order the documents immediately. Because if you have a contract that comes in on the property, okay, then listen to this. If you give the documents to them before ratification, within 3 days or up to 7 if extended, you know what that means, okay? After the date of contract, if on or before the date that the buyer signs the contract, buyer receives resale certificate disclosure packet, notified the packet is not available, or receives a packet not in conformity with the provisions of the Condo Act. Not in conformity means doesn't have all 19 items. If they receive it prior, then you know before the contract is ratified, that you'll know in 3 days whether they're going to back out for these condo docs. Okay? Well, most people don't do that. So let's say we look at number 2. The docs are received after, okay, after ratification, okay, within 3 days or 7 days if extended by the real estate contract, okay, which can be an addendum afterwards, right? Notice after receiving the resale certificate disclosure or notice that won't not be available, or once again, not in conformity with the POA Act, is hand delivered, delivered by electronic means, or delivered by commercial overnight delivery service, postal service, and a receipt obtained, then there's 3 days or up to 7, right? If it's delivered in one of those methods. Number 3, within 6 days or up to 10 days if extended by the contract, if the postmark date in the resale certificate disclosure packet. So if I send these things, return receipt requested, it's 6 days from the postmark. That's one way that you can actually prove. I don't care if they were home to receive them or not. I don't care if they were on vacation. If I can show that it was sent to the hard copy address, or yes, well, it'd have to be the hard copy address by certified mail, then we start counting the days, right? At any time. Number 4 is very important because I get this one all the time. I know Maribel went through this with an agent, and we just couldn't make them understand. At any time prior to settlement, if buyer has not been notified that the resale certificate disclosure packet will not be available and the packet is not delivered to the buyer, any time up until we receive the documents or a notice that it's not available, we have the right to void the contract as a buyer without giving any explanation. You don't have to give an explanation. They just turning it down because they haven't received the documents. And agents will tell you, no, you don't have the right to do that. You have to wait until we deliver the documents. No, you don't. It's very specific in our law. It used to be in our sales contract. It has now been removed. Okay. So that's the importance of this document, having the buyer acknowledge it and having it in your folder so that they're put on notice. Now, you may need a copy of this form actually to show listing agents who are trying to tell you, no, you don't have the right to do this, right? You have to wait. And come on, listing agents, why would you want to hold your seller's property up for that additional time off the market when you know the buyer is going to void the contract because of the documents even after they receive them? That just doesn't make sense to me. Okay. And notice of cancellation shall be provided to the seller by one of the following manners: hand delivery, and once again, doesn't have to be proven. You're going to have, well, technically, I would probably want something signed by them that they'd received it, because the law says the sender shall have the burden to demonstrate delivery of the notice of cancellation. I'm probably going to send it a different way: U.S. mail, postage prepaid, electronic means that shows that I have sufficient proof of electronic delivery, which is an electronic receipt, or sent by facsimile, if I can confirm the electronic delivery. So I probably would use one of those methods other than hand delivered, unless somebody would sign for it. Broker can cancel buyer on real estate matters, but if legal advice is desired with respect to contents of the resale certificate disclosure packet, buyer is advised to seek legal counsel. I know I've had this question. They want us to review it and tell them what's in it. No, we don't do that. That's not what we do, right? You can flip through it and discuss stuff with them, but you don't review and make the decision for them. So this is a very good form. I like this form, and I think it should be used with every transaction. Matter of fact, we discussed useful information about real estate transactions on Monday. I said that should be in your packet that you give to people up front when you start working with them. This might be another one that you want to include in that package if they're looking at properties in a POA or condo. And it has to be in a POA or condo association to, be even discussed. Any questions about paragraph 8 or 9 of the sales contract?
Larry,
Yes.
you say the statute says they have to deliver it, or by the mail or something, but not the email. If they send by email, that's don't consider.
If you send it by email, that's fine, because as long as you can prove that you have a receipt that it went through to the other email address.
I see.
Okay. So what if it goes into their junk mail? Well, then it's still been delivered, right?
Yeah.
But it's up to you to prove that it was actually delivered for voiding the contract.
Okay.
Okay. So if they're going to void, and it's got to be in the right time frame, the 3 days or no more than 7 if everybody agreed to it.
I have one
Any
question.
others? Yeah.
Yeah, if the association is governed by 2 or 3 associations, so when it's going to be, the last date for the buyer,
So-
cancel the contract?
So our statute says if there's both a POA and a condo, the 3-day right of rescission starts after the receipt of the last package.
Gotcha.
Okay.
Thank you.
So you don't have to void on POA if you got that one first, and you get the condo package a week later. Then the time starts with the last package receipt. That's in our statute. Okay.
Thank you.
Any other questions? Okay. Next Wednesday, I am going to do paragraph 10. That is the condition of the property as of what date. We will also look at the home inspection addendum, the home inspection removal addendum, and the notice to void. But I want to talk to you just briefly about the notice to void. If you are going to void the contract for condo or POA, okay, the law is very specific. You have to kill, then plead. Okay, you have to void the contract. Don't send over a release of contract and release of deposit. That does not kill the contract. Okay, you have to give the notice to void. There is an actual form in NVAR called notice to void. Okay, once you notice the void, then you attach the release of the deposit in the contract. Okay, but when you send over that addendum form, release of contract and deposit, you're asking the owner to please think about letting you out of all the terms of the contract. So if that's what happened and there was no notice to void, I'm going to take the position as the seller, you missed your 3 days. Okay, but you're going to say, well, we sent over the release of the contract within 3 days. That's not what the law called for. The law said you had to kill the contract, not ask to get out of it. You understand the difference? Okay. So anytime you want to void a contract in accordance with the terms of the sales contract, kill the contract first. Use the notice to void, which we'll look at next week. And then use the addendum form asking to be relieved of all the other responsibility and give me my money back. 2 distinct actions. Any other questions?
So send the contract with cross mark on a void, right?
No, you would
Residential.
actually have a form that's in the contracts package. If you have your contracts package there in front of you,
Yes.
let's go back to, let me take you back to page 38. I was going to do this next week, but since we have a little confusion, if you go back to, and I'll still do it next week anyway, but page 38 in the sales contract package, it should be a form that says notice voiding contract. That is form K1367. So if you're going to void because of the documents, it's the best way to do it would be use this notice voiding the contract. But technically, if you sent anything in writing, killing, okay? So I'm not going to get into whether a judge would consider an email a notice. I'm just going to use this form, safest way to do it. Whatever you do, make sure you kill, all right? So notice voiding the contract is given on such and such date. Notifying party declares the contract void is permitted pursuant to paragraph 8 of the contract. Now you've killed it, right? And then on page, I believe it's 18 or somewhere around there, of the contracts package is the release form that you would send over.
Right.
And the release form is saying, now that we killed it, so page 15, now that we killed it, we would like our money back. Okay? Do it properly. Kill first. Don't ask for a release first. Okay? That's what our statute calls for.
Okay, we got it. I got it. Thank you, sir.
Okay?
Thank you.
Any other questions?
That's it. Thank you. Got it.
Okay, I don't want to start any other paragraph today because we wouldn't be able to do it justice in the little bit of time we have left. So on Monday, I'll be dealing with the agency statute to deal with POA, and we will take a look at a little greater detail of that and ask Larry any questions you might have. And then next Wednesday, we will cover paragraph 10, the actual home inspection addendum, and also the addendum for asking for stuff to be fixed. Any other questions about anything while we?
Larry,
Yes.
I have a question, not for HOA, but it's different.
Okay.
Can I ask?
Sure.
Okay, I'm the listing agent for one property, and when we put on the market, we got maybe 10 offers. I can remember right now how many offers we got. And then the settlement supposed to have yesterday, but the seller signed the paper, but the buyer say no, they need 2 more days. And I'm trying to find out what is happening with what the buyer needs 2 more days. And I found out that the buyer have a condo that needs to sell, and they never put that contingency in the contract. I know for sure if they put that contingency, my seller never choose that kind of offer, no? Because the market is really high. My client choose the offer that they think is good. I say, okay, this lender, I don't like too much, but okay, they choose that offer, and the seller say, okay, this is the offer that I want for my house. Okay, finally, they don't close yesterday. They asked for 2 more days. After I let my clients know, the sellers, that the buyers have a contingency, sell a condo, and they can close until the condo is sold. They say, why you never told me that? I never got that. I never know that. And they say they want to punish the buyer for 2,000. If they want to close, they need to give the seller 2,000. Because one of the sellers is out of the state. They need to send the paper overnight, sign. They cost at least 500 to send that paper 2 times to, be ready for close yesterday. They move out, they pay for cleaning the house, everything that they did, and they don't close. I spoke with the buyer agent, and he says, no, there is no contingency. We have the money. I called this morning. I sell the addendum last night. I said, we have to have the addendum before 9 p.m. He said, okay, I'm gonna send the addendum. Can you make the changes on the addendum? I made the changes. Then he say, my client, they call me. I'm showing house. They call me and say, no, it's too much money. My client says, if we close today, 800. Close on the 30th, it's gonna be 1,500. They say, okay, I'm gonna make the changes and send later the addendum. I never received the addendum, and right now they are calling. The contract is it's dead, no, because we have to close last night. We don't have an addendum. They say about 2 minutes ago, they sent me an addendum for the buyer agreed to pay 250. My client said it's ridiculous. They don't have the deposit. They want the deposit. The deposit is 25,000. And my client said, put the house on the market. I say, I don't know. Let me check with my broker what I need to do. Yeah.
Technically, you have the right to put it on the market because the contract is no longer in effect, but they need to get legal advice. Okay. Because it did not settle when it was supposed to. They misled when they entered the contract, saying they didn't have a house to sell. So, they need to technically, if you looked at the time is of the essence paragraph, it says that they lost all contractual rights as of the date of settlement, which is already passed. So I think your person has the right to go ahead and put it back on the market. But once again, I would say tell them they need to get legal advice. We can't give them legal advice.
Okay.
You might want to submit that question to the legal hotline at NVAR. Okay.
Okay.
But it says in our contract that no part of the down payment would be from a house that has to be sold. So they misrepresented from the beginning. Does your seller really want to start over out of a house that they've already
No, they
moved out of?
they ask for 2,000 because it's nothing that they say I want to put them house on the market because we don't know if the condo is gonna sell. I called the buyer agent for the condo and they say they're gonna close on the 30. I want to make sure I send a text message, make sure that the condo is gonna close. No, she says she's gonna close on the 30 because the contract that they have is scheduled for close in 2 days. I say, okay, we need to wait for the condo. I spoke with the lender for the house that we have, and they say, well, we are clear to close. We only need the condo. Send the paper that the condo is closed. Yeah.
Yeah.
But my client wanted 2,000. They say, I want 2,000 because it's not good for the real estate agent that put that they don't, it's
how much more are they going to lose if they have to wait another 30 days to settle?
My client?
They're probably going to lose more than the 2,000 they're asking for. But paragraph 15 of the sales contract, okay? Paragraph 15 of the sales contract, buyer representation, it says in dark print, unless specified in a written contingency, neither this contract nor the financing is dependent or contingent on the sale and settlement of lease of other real property. So they're definitely in violation. If they had to sell a condo to sell, they were definitely in violation of the contract. So at this point, that's where your seller probably needs to talk to an attorney about damages and that type of thing. Under paragraph 26.
Yeah, I don't think it's fair for anybody to trying to miss that kind of contingency.
Yeah. Well, I mean, to send an addendum over after a contract no longer exists is it's like putting a fancy bow on a coffin. It doesn't change it. It's still dead. So, but they need to get legal advice to that point. We can't give the legal advice, but I think, as of midnight, they had the right to put the house back on the market.
Okay.
But, also double check with Kevin.
Yeah. Okay. Yeah.
He's your manager.
Yeah, I know. Thank you, Larry.
Larry, they could put the house in the market if they don't have to release it?
No, there is no release of a dead contract.
Okay. Thank you.
I mean, if you look at paragraph 30, I think it's 35 of the contract. Let's see. Okay. Let me pull it out real quickly. Paragraph 35, time is of the essence, means that the dates and time frames agreed to by the parties must be met. Failure to meet the stated dates or time frames will result in waiver of contractual rights or will be a default under the terms of the contract. They defaulted as of midnight of the day of settlement, okay? And they've lost all contractual rights. It's a waiver of contractual rights. So if time is of the essence is in your contract, you can't miss settlement, okay? You need to get that contract extended before settlement, not after, okay? So, but they need to get legal advice. We can't give them legal advice, but, if they've lost all contractual rights under the, they waived all their rights by not settling. And we entered a contract under false pretenses. It said right in paragraph 15 in dark print. I mean, it's highlighted that, if you have a house to sell, tell us. I mean, and this is what happens when you have a hot market and everybody knows that the property is going to sell, but then to get it to settlement. So in the contracts, contingencies and clauses addendums, that's why you use the, we have a house to sell, and be truthful, because it says right in there that sale of buyer's property, that if an additional amount of time is necessary to get this to the table, it can be extended for up to 10 business banking days, or 10 business days. So if they had used the proper thing, they wouldn't have been in a bind like this and then default. And the reason that the other agent probably didn't want to do that is because their contract wouldn't have been accepted if there were 10 other offers. Okay. So, I mean, I think the seller's entitled some damages, but to be under paragraph 26 of the contract, where they have to go back now and sue the party for the breach of the contract and the default. Or they can be nice and say, we're putting the house back on the market. If we don't get any other offers and you can make it to the table, we'll still settle with you. But, at that point, they need to get attorneys involved for damages and that type of stuff. And they're not automatically entitled to the earnest money deposit, because that belongs to both parties until a release is signed. So that money could be tied up forever.
Larry, do you know any good attorney, real estate attorney?
No.
Thank you.
Hi, Larry.
But I would probably talk to S&T Law Group. Sarah used to be the board's attorney, and she started her own private practice. It's called S&T. Okay. S&T Law Firm. Sarah Petra. Okay. But I hope to never have to use an attorney. I try to do everything right up front. So, any other questions?
Hi, Larry. Is there any CE classes in August that you offer?
I am offering them through the board on Zoom. Okay. The second and third week, it's a Friday and Saturday. We do 4 hours each day. But that's the only thing being offered right now is Zoom classes.
Zoom classes, all right.
No in-person. Okay.
They will get the credit for that?
If you do it through NVAR on Zoom with me,
Yes,
you
okay.
get the same credits as if you were sitting in the classroom.
Okay.
All right, thank you.
Okay?
Friday, Saturday, you say?
Friday and Saturday, the second and third week of August. You can register through NVAR to take those.
Sure, thank you.
But I'm not going to be in front of a live group until this virus thing is cleared up somewhat, because I'm 73 years old. I don't want to.
Yeah, I agree with you. Me too.
I'm in excellent health, but I don't want to tempt fate. Not for a little bit of money that you get paid. I'm just a poor teacher. I don't get paid very well. Any other questions?
No.
Well, thank you for joining me. I hope that was helpful. We will take a deeper look at the POA and Condo Act Monday and ask Larry. Okay?
Okay.
Thank you for attending.
Thank you, Larry.
Thank
Bye-bye.
you. Bye.
Thank you so much, Larry.
Thank you very much.
Thank you, Larry.
Thank you guys for attending.
Thank you, everybody.
Larry.
Thanks, everybody.
Thank you.
Thank you. Bye.
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 Bye-bye.
Bye.